Now, let's set the table for what we're going to see today and in the coming weeks with John Malcolm, Vice President for the Institute for Constitutional Government at the Heritage Foundation, and former Chief of Staff to the Senate Republican Conference, Ron Bonjean. Ron was also a communications advisor for the confirmation of Justice Neil Gorsuch. John, first to you, we still continue to hear that the president shouldn't even be doing this today, that the Senate shouldn't take it up. How do you respond to that from a historical perspective, but also a constitutional standpoint?
Well, there's certainly no constitutional impediment. The Constitution just says that the president nominates and the Senate can give its advice or consent, or it can decline to give its advice and consent, which is what it did with Chief Judge Merrick Garland. He was Chief Judge at the time. So in terms of our nation's history, there have been 19 times in an election year in which a president has made a nomination in which the Senate and the White House were controlled by the same party. 17 of those nominees were confirmed. 10 times a president has made a nomination in an election year when the Senate was controlled by the opposite party. Only 2 of those nominees were confirmed, and the last time was in 1888. So, certainly in terms of precedent and in terms of the Constitution, there is no impediment to what the president and Leader McConnell are doing.
Ron, take us through the process now. First, from a communication standpoint, what do you think Judge Barrett should say today in her remarks? And then what kind of activity will the nominee immediately be engaged in to prepare for what is going to be a bruising confirmation battle?
Yeah, I think those are great questions. The first thing that Barrett will do if nominated, she's going to give a speech from the Rose Garden. This is her first chance of making an impression to the American people and to the senators that are going to confirm her. She is likely going to tell her story about her upbringing, about her education, about her time on the bench, her philosophy. She's going to paint a picture of herself, both from a personal standpoint and a professional standpoint. It's somebody that is a wholesome family, law-abiding citizen that has grown up and lived in Indiana, gone to Notre Dame. And she will also talk about the fact that she was a clerk for Antonin Scalia. She's an originalist, someone who follows the law directly. And, I think this is her real shot at making a good first impression because the Democrats are going to be right out there trying to define her. She and Republicans will be trying to define her character. Immediately, Democrats are going to try to paint her in a bad light. Now, what will happen next week is she's going to start meeting with Republican and Democratic senators, most likely Republican first. Mitch McConnell will be the first person that she meets with. She'll also have very little time to prepare for a hearing, if indeed it's going to be held on October 12th. It's probably the shortest amount of time a nominee has had to prepare. So she's going to have to be going to meet with senators on Capitol Hill, at the same time, going to the old executive office building and start doing mock hearings, preparing for the grueling 3 days under the spotlights when the Senate Judiciary Committee holds its hearing.
John, Americans are going to hear a lot of terminology over these next several weeks, like textualism. They're going to be hearing about Roe. They're going to be hearing about cases like Casey and Obergefell. Take us through some of what we're going to be hearing, and maybe some of the cases that and put it in context for us, because the Democrats are already starting to throw this stuff out there, and it's important to inform Americans.
Well, I believe that what Judge Barrett will do when she's before the Senate Judiciary Committee is to follow the same rule that Ruth Bader Ginsburg did, which is to say she will offer no hints and no suggestions when it comes to cases upon which she would likely have to rule should she be confirmed to the Supreme Court. So textualism and originalism really just say that she is going to follow the law as written and as it was understood at the time that law was passed or a constitutional provision was ratified. The Democrats are always going to want to talk about cases that they like and try to get her to suggest that these are not only precedent, all Supreme Court opinions are precedent until they're overturned, but that this is somehow super precedent, which absolutely should not be touched. She will, decline to do that, to give those assurances, other than to say she respects precedent, and she will talk about the standards that justices should use with respect to approaching precedent. She knows a lot about that. She's written several scholarly law review articles on precisely that topic. And there'll be all kinds of issues: abortion, the Second Amendment, religious liberty, campaign finance laws, the First Amendment, you name it, she'll be talking about it.
But, John, in her confirmation hearing, and I recently watched the entire confirmation hearing from 3 years ago, they did talk a lot about precedents and super precedents. And, when you're up for an appellate judgeship, you get to say, I am bound by stare decisis. But that's not really the same as what she's about to go through, because she is going to be asked, you're not now bound by stare decisis necessarily. And do you think that she has to have a different approach, or is there a different approach for the way that Supreme Court nominees can, have to handle these types of questions?
Yes, she will. She will say that she's not going to offer any hints or suggestions. She will talk about a general approach to stare decisis. But you are precisely correct. As a lower court judge on the Seventh Circuit Court of Appeals, she was bound by whatever the Supreme Court said. And in fact, in one opinion involving abortion, which was sidewalk counseling, she wrote an opinion saying, "Look, I think that this ordinance is not in keeping with the First Amendment. But there is a Supreme Court case that is directly on point. This law is exactly like the one that the Supreme Court upheld in that case, and therefore I'm going to apply precedent." But the rules change once she becomes a Supreme Court justice, and will have more flexibility, along with her fellow justices, to re-examine precedent.